Angela Cornford-Smith and Brooke Thompson. I think I've got everyone. Good morning, everybody. Good morning. Thank you for being here.
Thank you for having us. We appreciate the opportunity.
Thank you for your attendance. Thank you for your written submission, and thank you for the work you do.
Thank you, committee. Thank you.
I'd now like to call representatives from the Queensland Law Society. Rebecca Fogarty, Angela Cornford-Smith and Brooke Thompson. I think I've got everyone. Good morning, everybody. Good morning. Thank you for being here.
Thank you for having us. We appreciate the opportunity.
Rebecca, you know the game. Opening a statement of 5 minutes, after which committee members will have some questions for you.
Thank you for inviting the Queensland Law Society to appear at the public hearing on the Births, Deaths and Marriages Registration Bill 2022. In opening, I would like to respectfully recognise the traditional owners and custodians of the land on which this meeting is taking place, Meanjin. I recognise the country north and south of the Brisbane River as the home of both the Turrbal and Yagara nations and pay deep respects to all elders past, present and emerging. The Queensland Law Society welcomes the introduction of the bill and its objectives to strengthen the legal recognition of trans and gender diverse people and to better recognise contemporary family and parenting structures. The bill proposes a new framework for the registration of a sex descriptor, where a person may register a sex descriptor of male, female, or any other self-chosen sex descriptor. The ability to register a self-chosen sex descriptor allows trans and gender-diverse people to self-identify and to have this self-identification acknowledged in the register. Whilst we support the underlying policy objectives, members of some of our legal policy committees have expressed concerns about the lack of certainty around how the framework will operate in practice. Members of our Criminal Law Committee have queried how the law will apply where a person is required to be subject to an invasive search. Members of our Succession Law Committee have noted some uncertainty in the area of wills and estates. Our key recommendation is that an audit should be conducted of all Queensland legislation that refers to sex and gender. This would allow for a comprehensive review of unintended consequences. This recommendation has been made by other submitters. I'm joined today by Angela Cornford-Scott, Chair of the Succession Law Committee and an accredited specialist in succession law, and Dr. Thompson, a senior policy solicitor of the Law Society. We're happy to take any questions.
Thank you. Laura?
Thank you, Chair. Thank you, and thank you very much for your appearance. I just was hoping that you might be able to talk the committee through some practical examples that your policy committees, both those two committees that you just raised, may have encountered or may have come across in relation to unintended consequences. So is there anything that you can elaborate? Yeah, thank you.
Thank you. I'll speak in relation to the Succession Committee.
You.
So the concern that we have in relation to, I guess, the effective sections 47 and 58 is the interpretation of a will, particularly when we're looking at class gifts, gifts to daughters, gifts to sons, gifts to nieces, gifts to nephews. And we think it should be clarified in the legislation as to when that sex should be recognised. Because under the legislation as it's currently drafted, once that certificate is amended or then that sex changes. But for the purposes of the construction of the will or the interpretation of the will, then that creates some uncertainty. So the position at law generally is that a beneficiary is identified at the time that the will is made, obviously because the will maker knows who they're talking about at that point. So if this changes that law, then that does create some uncertainty, certainly for the public at large who are preparing wills, but also practitioners who are executing them. And our concern would be that it could give rise to issues of construction which would have to go before a Supreme Court judge.
Thank you. There was another policy committee, sorry, that mentioned some unintended consequences.
I can probably speak to that. And for criminal lawyers, the issue, for instance, is of invasive strip searches. Generally, the legislation requires the Criminal Code and Police Powers and Responsibilities Act and associated regulations require that invasive searches of a prisoner or a person under arrest be performed by a police officer who is has the same sex as the person to be searched. What the bill does not do is clarify for us what that means if the person to be searched self-identifies in a way that is not male or female, and what that means for the agency who is undertaking the search. Is the focus to be on self-identification and being searched by a police officer, for instance, who identifies as the same gender as the gender diverse person being searched, or does it relate to, is it an anatomical construction?
John?
Yes, Ms. Fogarty, just following on from that, would you be able to comment about where are some of the potential unintended consequences in relation to invasive searches? Could you just elaborate a little bit further about where some of the risks might be, whether on the officers involved or the people being subjected to the searches?
I think the risk is more to do with ensuring the dignity of the person being searched and the appropriateness of the search.
And what about the legality of it on the part of the officers who are undertaking it?
That is an issue. That is an issue. I hadn't thought of that, but yes, I think that would be an issue, and we can develop that on notice if required.
That'd be appreciated. Thank you.
I can probably add to that too. Where in the explanatory notes, it talks about, in relation to that effect provision, the example given is the Surrogacy Act and the use of the term birth mother, and that anyone reading that act and that term would take that to relate to the anatomical capacity of a person. So it could be a trans man who can give birth. You would fall under that definition, but it's not so clear what the relevant criteria is when we look at some of those other areas like invasive strip searches, and whether the relevant criteria is the person's registration, what sex they have registered in the register, or whether, because by its very nature a strip search involves a person revealing intimate parts of their body, whether the relevant criteria would be the person's anatomical capacity.
Yeah.
And that's why we recommend that an audit be undertaken to clarify the relationship of this Act to other acts where sex and gender are important to construction.
So just touching on what Ms Cornford-Scott's said in relation to succession, it certainly does create some uncertainty. In relation to the audit, in relation to unintended consequences, can you see anything of a nature of transitional provisions in the bill that will actually guard against these, given that this bill is now before the House and it will be in effect before such an audit is undertaken?
I've gone through the DJAG response to submissions and noted that they've stated the bill will commence by proclamation, which is supposed to give the relevant government departments lead in time to work through these issues. So I think there's been some consideration of that particular issue, but we would still recommend that a comprehensive audit be undertaken of all the relevant pieces of legislation that use the terms sex and gender, noting that this was done in other jurisdictions as well.
Prior to proclamation?
I understand, yes. The Tasmanian Law Reform Institute did a comprehensive review. The South Australian Law Reform Institute, they produced a 150-page report going through each piece of legislation that used these terms. I think it was recommended by the Western Australian Law Reform Commission and the ACT Law Reform Commission as well.
Thank you.
Sandy?
Thank you, Chair. Good morning, Ms Fogarty. You have noted in your submission that previous consultation drafts of the bill contemplated distinct separate concepts for sex and gender, but that this bill now diverges from that approach. And that was on page 4 of your submission. What do you see as the impact between what the drafts of the bill contemplated, but what we are actually doing the inquiry into now?
I can probably speak to that. Thank you for the question. The previous draft of the bill that we saw followed the Tasmanian approach more closely, which proposed a gender registration framework, and I understand a number of stakeholders identified that there would be certain issues arising out of a gender registration framework. This bill removes that distinction and proposes an alteration of sex framework, and so we think that putting aside any issues relating to sort of the distinction between sex and gender and the debate on that issue, that we need to look at this more closely in terms of how it applies in different areas. And that's really goes to the heart of our recommendation about the need for an audit. And can I do a follow-up question,
Yes.
Chair? Please. Yes, given we heard this morning that there's been consultation on this for the last 10 years, even though I was totally unaware of that. In that 10 years, that would have given plenty of time for an audit before proclamation, as you've just said previously. Has anyone brought it up in that process?
I think the reality is that an audit needs to be assessed against the terms of the actual bill that's under consideration. Certainly the discourse has been going on for some time, and the Queensland Law Society has welcomed being part of that discourse, but we're talking about the specific terms of this bill.
All right, thank you.
Jonty?
Thank you, Chair. Good morning. Thank you for your submission. A lot of my questions have been answered. I did just want to come back to the comments made around policing, and you might not be able to comment on this, but I was thinking in your capacity, what's the current practice by QPS? Is it a matter of them having to cite a birth certificate prior to conducting those types of searches, or is it a self-report? If a person identifies as a woman, are they taken to be a woman, I guess, in practice?
My understanding is that the Police Powers and Responsibilities Act uses the term sex.
Yep.
And so in order for a person to be searched by someone, it must be a person of the same sex. And I believe that refers to their sex that's on their birth certificate, which would be the sex that you have at birth, or whether you've undergone medical intervention to change your sex. So this bill proposes changes to that framework. But again, we don't know how that is intended to apply in practice.
Yeah.
And it is a significant issue in that all of us who practice as part of the criminal law community have seen an increase in the number of people interacting with police who identify as trans and gender diverse. It's important from the perspective of the police to have that clarity.
And do you have examples from your community of perhaps trans men or women who have requested a search to be completed by a particular gender and that's not been able to be fulfilled?
I don't have examples of where it's not been able to be fulfilled. The current policy of the Queensland Police is, as much as possible to facilitate.
Yeah. Okay.
A trans person being searched by a trans police officer, but that is obviously going to be subject to the operational requirements on police at that time.
Thank you.
Laura or John?
Yeah, I have a further question, and you may or may not be able to answer this, but it pertains around the debate around sex and sport. A number of submitters have raised concerns in relation to community sporting groups not being able to apply, maybe let's call them their own local laws in relation to determining whether or not a transgender person can compete in a certain sex category of sport. If Part 5 was to become law, would that open up certain sporting groups or community sporting organisations to some sort of to be sued if they choose to apply their own, let's call them their own sporting codes when they're assessing whether or not a transgender person can play in a certain sport?
So I think when I read the DJAG response to some of those issues raised, it is essentially that is the intent of this bill, that when a person registers as sex, they are taken to be that sex according to, whatever instance that then applies in. But we do still have the Anti-Discrimination Act. We have the ability to apply for an exemption. I think these issues were canvassed in more detail by the Queensland Human Rights Commission's report. But we certainly know that issue is not settled, and we would expect the exemptions process to be robust and evidence-based.
Yeah. And do you think that there's enough time? Do you think that the time frame for consultation on this bill has allowed for that to happen appropriately and allowed for there to be the appropriate safeguards and checks and balances that other submitters have talked about, including the Human Rights Commission, in relation to safeguarding rights?
We're always going to want more time.
I think we'd probably repeat the statements made by the Human Rights Commission previously. There's a lot of legislation at the moment for consultation. This one is obviously of interest to the broader community. You can see that by the number of submissions that have been received, and it's clear that people would have liked more time to consider the bill.
Including DJAG, who says in their submission that they've been impacted by the short timeframes to prepare a response to the volume of submissions received. So I think that speaks volumes about the truncated timeframe.
Sorry, I lost my way. Sandy, I think.
No, no further questions. Thank you, Chair.
Jonty? Oh, I'll come back to you. We've got time. Jonty?
Yeah, look, the member for Cromwell's raised it, so I'll go there. In relation to sport, however, would you agree with the view that this is an issue that the sporting sector has been working through in practice for a long time and it will not be resolved through this bill either way?
Yes, I would agree with that and note that nothing changes the reality of the sporting sector and community organisations to comply with the Anti-Discrimination Act and other laws that have already been in place.
Thank you.
Thank you. John?
Just on the succession law point, as the bill stands at the moment, if someone's made a will leaving inheritance to a daughter or a son and then there's a change of sex registered, does that effectively, would that disinherit someone or take them out of the scope of a will as it stands at the moment without any other change to legislation?
No, the legislation says specifically that the change of sex won't affect their entitlement. But the issue is if it's an obvious entitlement, and certainly if a will refers to a child by name, you're not going to have an issue.
Of course, yeah.
The issue is where you've got a reference to a gift by class. And so if you've got someone who wasn't previously identified as a daughter and was previously identified as a son, their gift as a son won't be affected, but now they're also getting a gift as a daughter. So that would affect the terms of the will in that regard.
Say that again. Did you just say that in that example, their entitlement as a son wouldn't be affected, but would also obtain an entitlement under the newly registered sex?
Correct. And I believe that's in our submission as a specific example of how we would see that it would work.
But that's really, isn't it? Because in the will, they're identified as a class rather than
Correct.
why they're...
Yeah, I understand.
Correct.
I wrote down your words previously, Ms Cornford-Scott, when you said it creates some uncertainty, and it's quite true.
Okay. Do we have Jonty?
No, I'm fine, Chair.
Right. Do we have any more questions from the committee?